Parents are led to believe that judges in divorce and family courts are acting in the best interests of our children. We trust these judges even if they have little idea how to raise them. But what is truly going on behind the black robes? Is there any real accountability? And have they seized too much authority over our families? Meet Leon Koziel, proud parent, dedicated citizen, and human rights advocate. He's been asking such questions for years as director of the Parenting Rights Institute. He also practiced law in trial and appellate courts for more than 2 decades, obtaining verdicts and judgments against some of the most prominent law firms in the country. His record was unblemished. But that was before he was forced to expose corruption that was harming his children and others for profit. Within weeks of his alarming testimony before the Moreland Commission on Public Corruption, Leon's daughters and ability to practice law were taken. He raised those girls from birth without incident, a high price to pay in a country which cherishes free speech, where countless dads sacrifice for our rights overseas only to take their lives after exiting these same courts at home. If they could do this to a prominent attorney and model parent, imagine what they could do to you. So why did they do it? What is it about Leon's public message that got them to retaliate so viciously? You will learn the answers in this video, one that could save thousands of dollars in court costs, and more importantly, your children. Leon Koziel founded the Parenting Rights Institute 10 years ago to educate victims through lectures, programs, books, and more. He has lobbied Congress, sought precedent at the Supreme Court, and traveled the country trying to get as many parents away from these courts as he could. This meant less money for lawyers who are not held accountable for the needless controversy they instigate. The same is true of the judges here. Many did the same things before getting on the bench. Most people do not know that Title 4D of the Social Security Act rewards family judges by the size and number of support orders they issue. Doesn't that make them biased, discourage settlement or mediation, and harm our Social Security system? To maximize federal revenues, family judges have resurrected debtor prisons on a pretense of contempt. Fathers, good and bad, have been targeted. Indeed, as much as 20% of county warrant lists consists of male support debtors. They are nearly 100% of those jailed without any criminal charge.
The focus on money has become so extreme that one dad in South Carolina was shot dead in the back, unarmed, by a traffic cop while fleeing a support warrant. Is our government now killing for money? Such barbaric practices yield other victims, mothers, sisters, and daughters, who are consequently traumatized. As more working moms go into these courts, they too become victimized. In the end, parents are blamed for the court-created controversies. The state can then make the case that child rearing should be institutionalized as education was. It is a $1 trillion industry eroding parenthood with each passing year. This industry was fueled by an antiquated child custody system which the Parent Rights Institute seeks to reform into a shared parenting module of child rearing. Such reform has had the support of experts and parent groups, but they are routinely overpowered by special interests and bar associations. Nearly 20 years ago, in the case of Webster v. Ryan, veteran family judge Dennis Duggan gave the following condemnation. At the outset, the court notes that the terms custody and visitation have outlived their usefulness. Indeed, their use tends to place any discussion and allocation of family rights into an oppositional framework. Fighting for custody directs the process towards determining winners and losers. The children always in the middle usually turn out to be the losers. This court has abandoned the use of the word visitation in its orders, using the phrase parenting time instead. If the word custody did not so permeate our statutes and was not so ingrained into our psyches, that word would be the next to go. This misplaced focus draws parents into contention and conflict, drawing the worst from them at a time when their children need their parents best. Family judges exercise power that may be the envy of the IRS, FBI, and CIA. Every aspect of your private lives can come under scrutiny without any wrongdoing. There are no juries or monitors here. The judicial commissions across the country investigate as little as 10% of complaints. Many have described this as a dictatorship when learning of the judicial immunity and deferences that these judges are given by federal and appeals courts. The Parenting Rights Institute was created to improve accountability. Its website alerts are tagged to judges so that the litigants can better assess their ethics. Here is a short list of judges we have focused on. Leon successfully filed for removal of his custody judge, Brian Hedges. Concerned that parents were not allowed in chambers for the interviews of his daughters, opposing lawyers nevertheless defended Judge Hedges, citing a reputation beyond reproach. Months later, that judge resigned after admitting to sexual abuse of his handicapped 5-year-old niece. New York Chief Judge Sol Wachtler was sent to federal prison for secretly harassing his mistress and her daughter for a bribe. He directed paid court staff to harm the licensing interests of the lawyer who was helping her expose him. In his book, After the Madness, Wachtler explained that judges are taught to think of themselves as gods. Brooklyn divorce judge Gerald Garson was also sent to federal prison after FBI agents proved that he had accepted a bribe to fix a custody case in favor of a father. In upstate New York, yet another judge tried the same thing in favor of a mother. Thomas Spargo was convicted by federal authorities for seeking a $10,000 bribe. In the Kids for Cash scandal, 2 Pennsylvania judges were sent to federal prison for accepting bribes from the detention center contractors. 4,000 juvenile convictions had to be overturned by the state Supreme Court, which had its own justices mired in scandals. One juvenile victim committed suicide, and his mother chastised these judges at their sentencing. A married Michigan judge, Wade McCree, presided over a child support case while getting the mom pregnant and putting an unknowing dad on a support monitor. He was removed from the bench, but the dad's lawsuit was turned down by the U.S. Supreme Court due to judge immunity. Can it be that adultery in chambers with a litigant is now a protected judicial act? Finally, we bring you a shocker from a place called Utica, New York. City Judge Gerald Popio was merely censored in 2015 by a judicial commission despite a hearing judge who found that he had made racist jokes to an African-American attorney. Asked whether the attorney knew what downstate blacks called upstate blacks, Popio did not receive an answer. He then stated, quote, "Country slurs. That slur will be omitted here." Gerald Popio was found guilty of numerous ethic violations. He's threatened to come off the bench and wipe a smirk off a litigant's face. He jailed men for contempt in violation of their rights. And because he was never removed, Popio was assigned to Leon's support and custody cases in 2018, resulting in a near-fatal outcome. Judge Popio was brought up on complaints of racism and bias against this civil rights attorney, but to date, nothing has come of it. These are only some of the judges who got caught. They can be found in courthouses across America.
Hello, I'm Dr. Leon Koziel, welcoming you into my home. I founded the Parenting Rights Institute some 10 years ago to help parents and families trying to cope with the problems that are rampant in our nation's divorce and family courts. Here at the Parenting Rights Institute, we offer numerous programs. We publish books. We network with victims all across the country. We make referrals, self-representation. We do so many things that have saved thousands and thousands of dollars to those who go into these courts with little knowledge of what's really occurring. This is an epidemic. It's not going away anytime soon. Instead, in my 30 years in these courts, both as a parent, as an attorney, and as an advocate, I have seen it get much worse. And it's not going to be corrected unless we tell our government that this is a problem they need to reform. Our courts, the judges who preside over these proceedings, and our leaders in Washington must get that message. And to that end, I am hoping that you'll join me in a march on May 3rd, 2019, beginning at the White House, ending on the steps of the Supreme Court, for a national shared parenting bill, a removal of the Title IV-D incentive funds that have become so abused, and a memorial to all the victims that have either committed suicide, fallen victim to parent alienation, all those premature deaths, people that could have been saved had this reform movement been more effective. And so I'm asking you to join me. All those that I met across the country, you know what I'm talking about, and you are not alone. So follow us on my website, leonkoziel.com, or Parenting Rights Institute, for updates on this march and for things that we offer that might help you. Please support us. We are a non-government entity. We rely on donations and your assistance to make this happen. And we hope to have a candlelight vigil as well in Washington on the evening of that day as a memorial to all the people that we have lost as a result of this epidemic. Thank you for watching.